আপনারা দেখছেন ক্রিমিনাল জাস্টিস।
সুপ্রিয় দর্শক, আমরা আমাদের ক্রিমিনাল জাস্টিস প্রোগ্রামের সেকেন্ড সেগমেন্টে আসলাম। আমি সলিসিটর শাফিউল আজম, প্রিন্সিপাল অফ আজম এন্ড কো সলিসিটরস, এবং আমার সাথে আছেন ক্রিমিনাল লয়ার স্পেশালিস্ট ব্যারিস্টার, আমার কলিগ ব্যারিস্টার এমিও ভলেনওয়াইডার। Being accused of a crime can be extremely distressing. কেউ যখন কোনো একটা ক্রিমিনাল কেসের মধ্যে পড়ে, ট্রায়াল ফেস করতে হয়, খুব ডিস্ট্রেসফুল হয় এই সিচুয়েশনটা, এগুলা ফেস করাটা। Not only can such allegations severely impact your reputation and livelihood, your liberty may also be at stake. শুধু আপনার যে রেপুটেশনের উপর আঘাত আসবে না, আপনার ফ্যামিলি লাইফ, এবং অনেক সময় আপনাকে কাস্টডিতে রাখা হবে, অনেক সময় বেইল গ্রান্ট হয় না। সো ইট ইজ ভেরি ডিস্ট্রেসিং সিচুয়েশন। If you are facing a criminal allegation, you need access to the best legal representation to defend you. আপনার বেস্ট রিপ্রেজেন্টেশন আপনার দরকার। যত ভালো সলিসিটর ব্যারিস্টার আপনাকে রিক্রুট করতে হবে, so that you can defend your case properly, who can help you protect your reputation, career and family. যে আপনাকে ডিফেন্ড করবে to protect your reputation, to protect your career and family life, who can offer you representation at all stages of proceedings from first interview to final trial. আপনার যে আপনাকে অ্যাডভাইস করবে from the first interview, পুলিশ স্টেশন থেকে শুরু করে একদম ট্রায়াল পর্যন্ত, যে থ্রু আউট দ্য কেস আপনাকে গাইড করবে। অনেক সময় একটা প্রশ্ন আসে, when should I seek advice? There is no stage that is too early or too late to seek legal advice if you consider yourself to be in trouble. In fact, the earlier you get an experienced legal representative on board, the more likely you are to avoid mistake at the beginning of proceedings if the matter proceeds to litigation. The fact is, যত তাড়াতাড়ি আপনি মানে একজন এক্সপেরিয়েন্সড লিগ্যাল রিপ্রেজেন্টেটিভ নেবেন, ততই আপনার মিস্টেক হওয়ার পসিবিলিটিটা আর থাকে না। শুরুর থেকে যদি লয়ার নেন, তাহলে লয়ার এটাকে সুপারভাইজ করবে, লয়ার কেসটাকে দেখাশোনা করবে ফ্রম দ্য বিগিনিং, তাহলে মিস্টেক হওয়ার আর কোনো সম্ভাবনা থাকবে না। So, seek advice from a specialist criminal defense solicitor as early as possible. যত তাড়াতাড়ি, যখন এই পুলিশ আপনাকে খুঁজবে, আপনাকে ডাকবে, ইন্টারভিউর জন্য আসো, তখন থেকে আপনাকে আপনার সলিসিটর খুঁজে বের করতে হবে এবং প্রপারলি অ্যাডভাইস এবং গাইডেন্স আপনাকে নিতে হবে। Can I change my criminal defense lawyers? এখন কিন্তু এই প্রশ্নটা প্রত্যেক দিনে প্রায় সময় আমার কাছে আসে। কেসের ট্রায়ালে চলে গেছে, কোর্টের মাঝখানে আছে, অথবা কোর্টে কেস অলরেডি চলে গেছে, সলিসিটর চেঞ্জ করতে চাই অনেক সময়, এবং কোর্টে কেস শেষ হওয়ার পরে সলিসিটর চেঞ্জ করতে চাই। এই ধরনের মানে কোয়েরিগুলো আমার কাছে খুব বেশি আসে, যেটা আপনাদেরকে জানতে হবে। ইফ ইউর সলিসিটরস আর বিইং ফান্ডেড বাই লিগ্যাল এইড, ইউ উইল হ্যাভ টু গেট অর্ডার অফ দ্য কোর্ট for legal aid to be transferred to your new firm of solicitors. যদি আপনি লিগ্যাল এইডের মাধ্যমে কাজ করেন, আপনি চাইলেই সলিসিটর চেঞ্জ করতে পারবেন না। ইউ নিড দ্য কোর্ট অর্ডার, কোর্টের পারমিশন নিতে হবে, কোর্টের অ্যাপ্রুভাল নিতে হবে to change the solicitor. You usually have to give good reasons as to why you no longer want the current solicitor's firm to represent you. আপনাকে ভালো রিজন দিতে হবে কেন আপনি ওই মানে পুলিশে যে সলিসিটর দিয়েছে তাকে কেন আপনি পুলিশ স্টেশনে যাকে দেওয়া হয়েছে তাকে কেন চান না, ভালো রিজন দিতে হবে। গুড রিজন যদি না দেন, then court will not give the permission. সুতরাং কোর্টের পারমিশন ছাড়া আপনি সলিসিটর চেঞ্জ করতে পারবেন না। The longer you have a request to transfer lawyers, the greater chance you have of your application to be to transfer being refused. যত বেশি দিন আপনি দেরি করবেন, ততই গ্রেটার চান্স থাকবে যে আপনার এই সলিসিটর চেঞ্জ করার পারমিশনটা, অ্যাপ্রুভালটা কোর্টে দিবে না। যখন এই কোর্টে চলে যায়, তখন এটা কোর্টের পারমিশন লাগবে। কোর্টের অর্ডার ছাড়া আপনি ওইটা করতে মানে ওইটা ট্রান্সফার গ্রান্ট না হওয়া ছাড়া আপনি চেঞ্জ করতে পারবেন না। সুতরাং আমি যেটা সব সময় বলি, যখনই অনেক সময় আমার কাছে এই প্রশ্নটা আসে, যখনই আপনাকে পুলিশ স্টেশনে ইন্টারভিউ করা হবে, ইন্টারভিউর পরেই আপনি বুঝতে পারবেন যে লয়ার আপনাকে রিপ্রেজেন্ট করেছে, পুলিশ যাকে আপনাকে দিয়েছে, ওই লয়ারের উপর আপনি হ্যাপি কিনা, সে আপনার সাথে বসছে কিনা, বসে কথা বলছে কিনা, ডিটেইলস আপনার ঘটনাগুলো শুনে আপনাকে অ্যাডভাইস করছে কিনা, অ্যাডভাইস করার পরে আপনাকে ইন্টারভিউ রুমে নিয়ে গেছে কিনা, তাইলে আপনি ওগুলো সব বুঝতে পারবেন প্রথমেই। মানে ওইটা শুধু ইন্টারভিউর মধ্যে নিলে হবে না, ইন্টারভিউর আগে কিন্তু ওই লয়ার আপনার সাথে বসে সবগুলা ডিসকাস করতে হবে, সবসময় ওইটা আপনারা করবেন। যদি দেখেন যে আপনাকে ওই ধরনের প্রপার অ্যাডভাইস দেয় নাই, আপনি তার যে রিপ্রেজেন্টেশন পুলিশ স্টেশনে যে দিয়েছে, পুলিশ যাকে আপনাকে মানে রিপ্রেজেন্ট করার জন্য অ্যারেঞ্জ করেছে, তার উপর আপনি হ্যাপি না, তাইলে পুলিশ স্টেশন থেকে বের হওয়ার সাথে সাথেই আপনাকে কিন্তু সলিসিটার খুঁজে বের করতে হবে। ওইটাই হইল রাইট স্টেজ। যখন ওই স্টেজে আপনি যখন সলিসিটার খুঁজে বের করবেন, তখন কিন্তু আপনাকে আর ওই কোর্টের পারমিশন লাগবে না। কোর্টে যখনই কেস যায়, লিগ্যাল এডের মাধ্যমে যখন হয়, তখন কোর্টের পারমিশন ছাড়া সলিসিটার চেঞ্জ করা যায় না। I will now pass to my colleague Barrister Amir Vollenweider to talk more on bad character, please.
Yes, so in the first section we were dealing with the definition of bad character and what was and what was not bad character. In this section I want to deal with the situation where there is bad character evidence of a witness perhaps against you and you're a defendant of good character. So you might find yourself in the position of being the defendant and you want to introduce a witness's bad character, perhaps because they're dishonest, or for example they're the ones who attacked you and you're running self-defense, and they've got previous convictions for assault, for example. Now, one thing as a word of caution I put again to you is that if you do put bad character to them and you have convictions or cautions yourself, the jury may be allowed to find out about them. So again, be careful, and again the same message as before really. You'd be wise to take specialist advice from a specialist criminal solicitor, a specialist criminal barrister as well, as to the final decision to make on something as important as character. Now, Section 100 of the Criminal Justice Act 2003 deals with that situation of a non-defendant's bad character, for example, a witness against you. And subsection 1 of that says this, that in criminal proceedings, evidence of the bad character of a person other than the defendant is admissible if, and only if, A, it is important explanatory evidence. So, for example, the victim, let's say, or alleged victim, has a motive to lie about you, and that motive is itself bad character. For example, he's a drug dealer to whom you owe money, though that would most probably fall into Section B as well. B, it has substantial probative value in relation to a matter which one is a matter in issue in the proceedings, and two is of substantial importance in the context of the case as a whole. So, for example, again, self-defense and the victim has previous for assault. That again may be very relevant. It's a matter in issue as to whether or not he assaulted you, and it's of substantial importance. And then C, all parties to the proceedings agree to the evidence being admissible. So, of course, if the prosecutor agrees to it being admissible, then you have little problem. So then we move on under the Act for the purposes of Section 101A. What is important explanatory evidence? Well, it's defined as it's important explanatory evidence if, without it, the court or jury would find it impossible or difficult properly to understand other evidence in the case, and its value for understanding the case as a whole is substantial. Now, in assessing the probative value for the purposes of section 101, 100 subsection 1b. The court has to have regard to the following factors in determining whether or not it does have that probative value and assessing that probative value. Firstly, the nature and number of events or things to which the evidence relates. So, for example, perhaps the number of previous convictions for a particular form of dishonesty that the individual has, and when those events or things are alleged to have happened or existed, and where the evidence is of a person's misconduct, and it's suggested that the evidence has probative value by reason of similarity between that misconduct and other alleged misconduct, for example, in being dishonest, the nature and extent of the similarities and the dissimilarities between each of the alleged instances of misconduct. And where the evidence is evidence of a person's misconduct, it is suggested that the person is also responsible for the misconduct charged, and the identity of the person responsible for the misconduct charged is disputed. The extent to which the evidence shows or tends to show that the same person was responsible each time. For example, you may say it was the witness who actually perpetrated the crime necessarily rather than you. So except where subsection 1c applies, that's the section where all the parties agree to it, evidence of bad character of a person other than the defendant must not be given in court without the permission, often called leave, means the same thing, but the permission of the court. So if you're going to put someone's bad character in, unless the prosecutor agrees to that happening, you have to have the permission of the court. And it's worth dwelling on that for a moment, because of course one would then ask, well, when should I apply? And the easy answer for those of you at home, and perhaps the cheat answer rather than going to the criminal procedure rules of 2015, which I'll refer to in a moment, but is really as directed by the court, because you will attend your first hearing, for example, in the Crown Court, a plea and trial preparation hearing. Used to be known as a PDH, changed some time ago. It's now the plea and trial preparation hearing. And usually such matters are determined before the commencement of the trial, even if on the day of the trial, whereas an application in relation to the defendant will probably be left until the prosecution closes their case. And there are forms which you can obtain online, but again, you're best seeking the advice of an independent specialist criminal solicitor about all of those matters. They're used to filling out those forms for you, and indeed, I would certainly consider that above all else. As far as the procedure set down by the criminal procedure rules is concerned, they apply both to the Magistrates' Court and the Crown Court. And there's a notice that has to be given. A party who wants to introduce evidence of bad character must make an application under Rule 21.3 of the Criminal Procedure Rules, where it's evidence of a non-defendant's bad character, and under Rule 21.4, where it's evidence of a defendant's bad character, though you're less likely to be concerned with that. And an application or notice must set out the facts of the misconduct on which that party relies, and explain how that party will prove those facts, whether that be by a certificate of conviction, which your solicitor may have obtained from you as part of the disclosure process, or other official record or other evidence, if another party disputes them. And you must explain, by reference to the Criminal Justice Act, why the evidence is admissible. Again, a tricky area for the layperson to deal with, and you would be best advised to seek specialist and independent legal advice from a criminal solicitor. Applications to reduce evidence of a non-defendant's bad character, they have to be served as well. That application must be served on the court officer. It must also be served on the prosecution as soon as reasonably practicable, and in any event not more than 14 days after the prosecutor discloses material on which the application is based. So ordinarily there will probably be a defence case statement in the Crown Court, and it may be as a result of that that the previous convictions of the alleged victim is disclosed to you, and it shows a rather worrying pattern perhaps of violence or dishonesty. And of course once that material is disclosed to you, technically you would have the 14 days in order to serve your application. But fret not if you've not done that, because there is provision, although one mustn't rely on it, for the court to vary that and essentially deal with it in a different manner. You can deal with it at court and make an oral application. But again, a risky strategy perhaps, because there's no guarantee the court will deal with it if the rules aren't complied with. So perhaps yet another reason why you should seek that independent specialist criminal advice from a solicitor. The power, in fact, for the court to vary that requirement, for those of you who are interested, comes under 21.6 of the criminal procedure rules. The court may shorten or extend a time limit under that part. It may allow the application or notice to be in a different form to the one set out by the practice direction, or to be made or given orally. Obviously key if for some reason you started out perhaps as a litigant in person, then at a later stage and very wisely sought independent specialist advice from a criminal solicitor. If you want an extension of time, you must apply when serving the application or notice for which it's needed, and of course you would have to explain the delay for not doing so. The next matter I would wish to go on to talk about is a defendant's bad character. It's important that people at home realise what hoops the prosecution have to jump through in order to put any bad character in relation to you if you face a charge and you want to know, well, you know, how might I be able to object to my previous convictions going in or otherwise, and on what basis might the prosecution be able to put in my previous convictions or cautions, or indeed refer to previous bad character, because it needn't be, for example, a conviction or a caution. It could be some form of reprehensible behaviour which in fact you weren't charged with. And so it's very important that one knows where the risks are when looking at a defendant's bad character. That's governed by Section 101 of the Criminal Justice Act 2003. And dealing with it, there are 7 gateways. I repeat, that's 7 gateways where bad character of a defendant is admissible, but the prosecution have to pass through these gateways. And so subsection 1 of Section 101 of the Criminal Justice Act of 2003 states that in criminal proceedings, evidence of the defendant's bad character is admissible if, but only if, A, all parties to the proceedings agree to the evidence being admissible. Well, probably unlikely that that's going to be the case unless your defence absolutely necessitates you perhaps putting in the bad character of that other alleged victim, in which case it's a balancing exercise, and again you'd be well advised to seek the advice of an independent specialist criminal practitioner. It's only admissible if B, the evidence is adduced by the defendant himself or is given in answer to a question asked by him in cross-examination intended to elicit it. An example there would be where you actually talk about perhaps one of your previous convictions, you're talking about the background to the case. I had a client once who came out with the fact that he was in the location he was at the time because he was smoking cannabis at the time. The danger with that is, of course, is it opens up himself to being cross-examined on his previous convictions. C, it is important explanatory evidence. D, it is relevant to an important matter in issue between the defendant and the prosecution. E, it has substantial probative value in relation to an important matter in issue between the defendant and a co-defendant, if you're charged with somebody else. And F, if it is evidence to correct a false impression given by the defendant. For example, you may have said in your evidence that you did some charitable work and didn't mention that you had a string of previous convictions for dishonesty, or you tried to portray yourself perhaps as a family man who would be horrified if your children got into drugs when you had previous convictions for drugs yourselves and were facing a drug charge. Well, then you're in grave danger of the prosecution applying and saying that evidence is admissible to correct a false impression that you've given. So again, an area where you have to be very, very careful and it would be well advised to take that independent specialist criminal legal advice. And G, the defendant's made an attack on another person's character. Well, of course, if you start impugning the character of other witnesses, having a go at their character, then quite frankly you can expect the court to allow the prosecutor to have a go at your character. But thankfully the court must not admit evidence under subsection 1D or G. That's the section where it's an important matter, it's relevant to an important matter, an issue between the defendant and the prosecution, or you've attacked the alleged victim's character. If on an application by the defendant or the defense solicitor to exclude it, it appears to the court that the admission of the evidence would have such an adverse effect on the fairness of the proceedings, the court ought not to admit it. So there's still grounds there for you to challenge it, and again you'd be best advised to seek independent specialist legal advice on it. And on an application to exclude evidence under subsection 3, the court must have regard in particular to the length of time between the matters to which that evidence relates and the matters which form the subject of the offence charged. And of course that stands to reason because of course if it's something very old it may really not be relevant at all. So dealing with subsection 103, that is, well, what is a matter in issue between the defendant and the prosecution? Well, for the purposes of section 101, subsection 1D, the matter in issue between the defendant and the prosecution include the following. They include the question of whether the defendant has a propensity to commit offences of the kind with which he is charged, except where his having such a propensity makes it no more likely that he is guilty of the offence. B, the question whether the defendant has a propensity to be untruthful, except where it's not suggested that the defendant's case is untruthful in any respect. I can't imagine many cases where that is the case. And subsection 2 deals with where subsection 1A applies, that's the propensity to commit offences of the kind with which he is charged. A defendant's propensity to commit offences of the kind with which he is charged may be established by evidence that he's been convicted of an offence of the same description as the one with which he is charged, or an offence of the same category as the one with which he is charged. Now, dealing with that section, it doesn't apply in the case of a particular defendant if the court is satisfied by reason of the length of time since the conviction, or for any other reason that it would be unjust for it to apply in this case. So one looks at subsection 103 2 and we see this, that two offences are of the same description as each other if the statement of the offence in a written charge or indictment would in each case be in the same terms, so exactly the same as what you are charged with, or two offences are of the same category as each other if they belong to the same category of offences prescribed for the purposes of that section by an order made by the Secretary of State. Well, again, a lot of legal jargon there. Really, there is a schedule that applies and is appended to this Act, which states all of those offences. Too long for me to go through here. But again, you'd be well advised by an independent criminal specialist practitioner, and I would recommend the same to you. Just finally on that point, of course, if something occurs outside, an offence occurs outside of England and Wales, and it would be an offence in this country, again, that's something that can be referred to, and indeed also foreign services offences, so those relating to military personnel. Before we go on to evidence essentially that is admissible at common law, I think we've probably reached the end of that particular section.
থ্যাংক ইউ আমিও থ্যাংক ইউ দর্শক আমাদেরকে বলা হচ্ছে একটা ব্রেকে যেতে হবে এবং ব্রেকের পরে আমরা আবার ফিরে আসব আমি সেলিস্টার শাফিউল আজম এবং আমার সাথে আছেন ক্রিমিনাল লয়ের স্পেশালিস্ট ব্যারিস্টার আমার কলিগ ব্যারিস্টার আমিও ভলেন ওয়াইডার সবাই আমাদের সাথেই থাকুন
আপনারা দেখছেন ক্রিমিনাল জাস্টিস